First, would you please rise, join us in a moment of silence and the Pledge of Allegiance by Councilmember Patana.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. And now we begin our study section of tonight's meeting. We cannot make any definitive decisions. It's an opportunity for us to interact with the staff and get information.
Thank you, Mayor Barrett, council members. We have 4 items on the study session agenda this evening. And the first was begun in your last meeting. Near the end of the study session, Jeff Tyne gave an overview of the issue to the council. And just as you were about to begin your conversation and deliberations, we ran out of time. So maybe the best thing to do would be to have Jeff give a very brief refresher, reminder of where the council left off. Jeff?
Great. Thank you, Mr. Swenson, and good evening. So as Carl had mentioned, I'll just give an abbreviated presentation. If you have questions, just let me know, and we'll make sure to go back to those slides. This began on August 27th. The City Council did discuss the current policies and practice with regard to political activity by agencies affiliated with the City of Peoria, and then as we had mentioned at our last meeting on October 21st, discuss that more in detail. Really, the way that staff framed this was a policy framework that rises to these 4 different considerations, and I'll go through those very quickly. The first was with regard to what kind of restrictions on political activity, and if you recall, we also had Steve Berg, our Assistant Chief City Attorney, as well, help with some definitions and explanations on that. Talk a little bit more about clarifying which agencies would qualify or would be associated with this policy. Next, we talk about what would be the potential enforcement provisions, and lastly, about how we would go about administering it, namely compliance and monitoring. First, with regard to restrictions, there's no defined policy that exists that restricts political activity for affiliated agencies. And many of the contracts that we have with the larger affiliated agencies now currently don't include a conflict of interest provision. That said, the city does have some contractual and code provisions regarding conflict of interest, and we had talked about a few of those. The Chamber of Commerce, our city's not-for-profit grants, and have some of those provisions. Vendor solicitations generally refers to a period of time during the solicitation when there would be no lobbying activities of the City Council until the end of that solicitation. So one of the items for discussion today is if there was a policy in place, what would those restrictions be like? And as we talked about last time, they could be restrictions on the agency activities or restrictions on agency officials. Second, with regard to agency definition, currently there are 3 different potential affiliated agency definitions that the staff had come up. One would be referring to the city's partner agency policy, which was something that was developed in the budget process for agencies that were seeking funds from the city that were a 501c3 that have a defined budget item, that have a community relationship with them that's longstanding here in the city. Those agencies have a funding piece, and that could be one type of activity. And the second would be if there was some kind of financial relationship. In other words, if there was a certain amount of funding that was afforded, if a percentage of the agency revenues was related, that could be another way that we define an affiliated agency. And then the last would be that the council, just at their discretion, could go through that. We went through a couple of what those would look like. The current partner agency, as it stands, the top 3 agencies would qualify in our existing budget process as a partner agency. If we were to go to a financial relationship, depending on the parameters, any number of agencies could be included. And of course, the council could, at their discretion, identify those agencies, whether it's at one point in time or as periodically. Next would be in a policy discussion regarding enforcement. A couple areas of enforcement that came to mind where we have contracts with these affiliated agencies. Of course, we could have some kind of clause within that contract that looks at either a cancellation or suspension of that. It could be within a financial withholding piece that is a clause, again, within a contract. Or it could also be a trigger of a financial review of that agency. In other words, if there was a restriction that was in question, those clauses could be put into effect. And then lastly, we talked a bit about compliance and monitoring. In other words, how would the city and the city staff go about monitoring these activities of these affiliated agencies? Would it be a proactive, or would it be something that just is brought forward? So for example, in the case that we see during election-based activities, oftentimes it's on a complaint basis that's brought to the city's attention, would be brought to probably the city attorney's attention for processing as well. The other option is that the city staff could provide a repository of this information of these different agencies, would likely include agency officials, those agencies, what the funding is. There would be some staff resource requirements that we expect if that's the interest of the council at that. So I think, I apologize, those are just some of those pieces. With that, that addresses the staff presentation. I can go to any one of the slides that you'd like as we go through this.
Okay. You brought this up. You have a preference?
Sure. Could you go back a slide or two?
Sure. Let me try here. Tell me when to.
That's good.
Okay.
Just wanted the various sections. So thank you, Jeff, for doing this. I appreciate the help, and I know, Steve, you're involved as well, so thank you for that. Looking at this, I mean, to me, it seems like starting backwards is almost a little bit easier. In terms of compliance and monitoring, I think I would submit to the council, and obviously this is open for discussion, that that complaint basis would probably be the best, so that we don't have red tape and, you know, additional processes that someone has to take care of. So then moving to, I guess my question here would be, do we want to discuss that, or do we want to, as we go point by point, or?
Yeah, let's do it point by point.
Okay.
Does anybody have any comment about that, any feelings either way?
Compliance monitoring? I mean, if we're going to have it.
Okay. This is if we adopt some kind of a policy. I'm sorry. It would be on a, handled on a complaint basis, just like violations of electioneering violations.
Mayor, Council, maybe I could address that in terms of how we handle it with campaign finance complaints. What we would do is we would require that there be a written complaint made, and then based on the nature of the complaint, if it appeared that there was probable cause, reasonable cause to believe that we had a violation, then we would require the entity to provide us information that would allow us to determine if we should proceed further. And this is what we do with campaign finance complaints. We basically make an initial reasonable cause determination, and then we just contact the entity, and we would then seek additional information that would allow us to determine whether we actually think there's a violation or not.
Okay.
Which staff? That ultimately, it would be a council decision. I think probably if we handle it the way we handle campaign finance complaints, it's the city attorney's office. And so I'm kind of thinking that, again, without presuming what the council would do, it probably would have to almost be the city attorney's office, and working, I'm sure we would work periodically with both the clerk and the finance department, but campaign finance complaints come to the city attorney's office for that decision, and I would think this probably would be the same.
Mr. Tillman?
Thank you. So, Mr. Kemp, who currently enforces contract provisions?
Right now, we work with the Materials Management Division of Finance, and depending on the nature of it, if it's something that Materials Management is able, they monitor and do contract management, and they enforce many provisions. If it becomes something that they have issues with, then we become involved. And so it's kind of a cooperative relationship with us in Materials Management.
And Councilmember Tillman, I can add to that as well. Often contracts are initiated and administered by a variety of different departments. And so the department that's providing the administration and oversight is often in a position to be able to identify contract issues and enforcement issues within contracts first. And they'll work with the city attorney's office and the Materials Management Division of the Finance Department if they're unable to get a resolution sort of at that department level. So if you think about a construction contract, for example, or a professional services contract, they're being administered by a department. So a director or a division manager within a department is usually the first line of enforcement on those types of contracts.
Right, but given that this is sort of related to campaign finance, I guess at some level, it would seem to me then that this would be something that the attorney's office would have to be sort of the initial point of contact for.
Yeah, it would absolutely differ, certainly, from the kinds of things that I was just describing, but I just wanted to make sure your question was
Thank you.
thoroughly answered.
Thanks.
Mr. Ames?
Yeah, are we talking about issuing the contract, fulfilling the contract, all of that here?
No, we're not talking about contracts here. We're talking, and we're getting off topic. What you're talking about is if there's a violation amongst the 501c3s. Because there's already a system in place for construction contract people that have those. You're just talking about possibly developing a policy that deals with the 501c3s that takes substantial money from the city of Peoria, right?
Correct.
So, no, it
Well,
isn't, it isn't a contract compliance issue. It's handled on a complaint basis. That's the question of the issue.
Okay.
And then they're saying the attorney's office.
But would this be issuing funds to the not-for-profit, or
No,
they're handling
you
of
do
the funds?
that through the budget.
Yeah.
This would be simply if council were to adopt a policy regulating political involvement in city campaigns and elections for those defined entities that council chooses. And this would simply be how would we handle the compliance. And what I seem to hear the consensus is that it's going to be in the attorney's office.
Lucky you.
So this is just a compliance in terms of campaigns?
In terms of that.
And funding campaigns and those,
In terms of that political activity issue.
not other issues?
Not
That was
other
kind of my
issues,
question.
just that.
Okay. Just essentially campaign issues. Is everybody all right with that? Carla? Yes, no?
Yeah.
Yes.
Yes.
We'll go to the next section. Given that there might be some misunderstanding on some of the points, perhaps we should start with the first point, kind of identifying the policy and then kind of going through.
Excuse me, I'll go back.
That's all right.
Okay, would you like me to perhaps go to this slide? Is that-
Yeah, that's good. That'll work. Okay, so looking at this, in terms of restrictions on agency activities, I'm fairly certain that sort of goes without saying, only because agencies, much like corporations, can't contribute anyway, correct?
Yes, Mayor, Council, not-for-profit corporations are prohibited by state statute from contributing to an election for any candidate. They can contribute to elections for issues, but they're prohibited from contributing to city candidate, in fact, state, county, all candidate elections under Arizona law.
Okay, so then moving on to restrictions on agency officials, could you explain just briefly, Mr. Kemp, how that would be limited to sort of executive level or managerial level employees?
Mayor, Council, this gets into some, it's restrictions on agency officials. This is where campaign finance and First Amendment, this is where we come together. Obviously, the First Amendment, as interpreted by the United States Supreme Court, creates a broad right for political speech. And political speech is included as the ability to contribute money. So speech is not just talking, it's opening up your checkbook. Now, what the courts have also said is that when we're not going to absolutely say you can't regulate it, we're going to say essentially to regulate it, you have to have two things. You have to have what we call compelling state interest. Now, compelling state interest is an interest so significant that it's compelling to warrant regulation, and it's a two-part test. You've picked the least restrictive means to protect that compelling state interest. So, for example, the city could not say for all not-for-profits cannot contribute to city elections. That would clearly violate the First Amendment, and However, on the other hand, the United States Securities and Exchange Commission has said that two limited classes of individuals, financial advisors and bond counsel, may not contribute to city office holder campaigns in those cities where they provide that service. I don't believe constitutionally this council, any council, could say, for example, boards of directors of a not-for-profit may not contribute to city elections. I think you would want to follow the First Amendment. I do think you could limit the ability of perhaps an executive director to contribute to, and it would have to be done by contract. It couldn't be, you just couldn't say so, it'd be really a condition of the contract. When courts have upheld this, courts have said it has to be limited and it has to be a compelling interest. For example, the state of New Jersey limits entities that have contracts with local governments. It limits those entities from engaging in this, but it requires it be a condition of each contract. And so, and I think you would become, you'd run more risk of becoming a follower of the First Amendment when we begin to look at contributing to city and council member activities and contributing to municipal ballot items. The United States Supreme Court has said municipal ballot legislation, initiatives, referendums is really First Amendment speech. It's exercising the power of speech. And that the same restrictions that we have for elected official elections may not be sustainable in those cases. City and council member activities, again, I think that could become so broad. Does that mean that, for example, city not-for-profit, we're going to call it ABC Dance Hall, can't contribute to the city's Easter egg hunt, can't contribute to any number of things? I think, again, you run a significant risk of being so broad in that definition that I don't think you can meet the compelling. I question what would be the compelling state interest, and two, what is the least restrictive means. But certainly, that's kind of, hopefully I painted the picture and answered that question.
Let me take a run and see if I understand it. Let's take TheaterWorks, because that was an issue that was brought up before. TheaterWorks, as an organization, cannot contribute to city elections,
That's correct.
to the council members' activities or municipal ballot items,
Yes. TheaterWorks cannot.
as an organization.
Under state law, they cannot contribute to council member elections. They could contribute to a ballot item, but not to council member elections.
They could contribute to,
An initiative or a referendum. That's a different statute than office holder
the
elections.
third one they could contribute to.
The third one,
Third
sitting
bullet.
activities, that's not addressed anywhere in campaign finance.
But anyone that's on the board of TheaterWorks can contribute their own personal money,
Absolutely,
anybody they want,
absolutely.
as
And
long as they're within the campaign
as
finance
long as
limits.
with it's their own personal money. If you'll recall, about 2 years ago, the Fiesta Bowl, this was one of the big issues in the Fiesta Bowl, was A, could you give corporate money to individuals to contribute to candidates, which, no, you cannot do that. Or can individuals give their money to other individuals to contribute under their name? No, you can't do that.
So the only, so the only one that's really valid here is whether or not they should be allowed to hold office. Is there any restriction on that?
The issue on holding office is that once you're elected and you take the oath, there's what we call the doctrine of incompatibility, which there are certain positions which it's viewed in the law that are completely incompatible. That, for example, the mayor of a city could not also serve as the a state legislator, because it's viewed that they would have divided loyalties, one to the state, one to the city. And so there are certain positions that are what we call inherently incompatible. Head of a not-for-profit and an elected official would not be, in the law, automatically incompatible. The remedy Arizona law provides for that is that an individual would have to declare a conflict of interest each time a matter came before the governing body where they had a substantial interest in the matter. Now, conceivably, you could have an individual having to declare a conflict of interest at every meeting. There's no legal restriction on how many conflicts of interest you declare. It may become a political issue, but that's not a legal issue. And from a legal standpoint, people can have repeated conflicts of interest, and they've complied with the law as long as each time they've properly declared the conflict of interest.
That would be recusing themselves.
Yes, when we talk about conflict of interest, you have to declare it with the clerk, and you have to recuse yourself and refrain from participation in the matter in any way.
Mr. Tillman.
Mr. Kemp, what we're actually talking about are two potential options here, right? In terms of potential restrictions on agency officials.
Yeah.
Specifically, what the options on the table are for the purpose of this discussion are holding mayor and council member positions in the city as one. The other is contributing to city elections. And if I understood you correctly, you did say that we could legally, without, in your opinion, conflicting with the First Amendment, restrict perhaps agency directors or managers, not necessarily board members, in other words, people that get a financial benefit from this agency, people that are, for lack of a better word, employed by these agencies, we could restrict them legally from contributing to city elections and from holding office. Is that correct?
I think we, if council directed, we could draft a narrow enough provision in a contract. I think it would have to be limited literally to only like an executive director, and I think the scope of this would also have to be limited to only those agencies where there's a significant city financial investment. I don't think, for example, the fact that the city may give a not-for-profit $5,000 means we could do this. If the city was essentially the sole funding of the not-for-profit, then I think that becomes a different issue. And I think we would have the issue in terms of holding office. There's a difference between running for office, which I think is a First Amendment protected activity. I don't think we can say per se that they cannot run for office. Now, the issue of holding office, while that not-for-profit is still doing business with the city, again, it becomes the same kind of issue if there is a significant financial relationship between that not-for-profit and the city. And so those would be the key things. And what I would sort of maybe try, because I know this is very complex, this whole First Amendment stuff, if you think of it as a continuum, if you stay, the further and broader you make this, the more difficult it is for it to be upheld. If you think of it as maybe like a funnel, if you have the end, the restrictions narrow like the bottom of the funnel, they're more likely to be upheld. If you're broad like the top of the funnel, then you're going to have issues with the restrictions in terms of them being too constitutionally broad to meet that test I spoke of at the beginning. Compelling state interest in least restrictive means.
So if,
Go ahead.
yeah, so if we were to say draft a policy that says holding, not running for, but holding these offices or contributing to city elections by executive directors of our partner agencies, as defined by Jeff earlier, that would not be too broad in your opinion?
I think we would be able to draft a constitutionally sufficient policy there. Now, keep in mind, this is one area that and the caveat here is the Supreme Court, if you followed campaign finance for things like Citizens United, the Supreme Court seems to be taking an ever-increasing view on political speech against any kind of restrictions. So I think we can do it constitutionally sufficient, but I have to tell you that one thing I want you to keep in mind is, because if you look at Citizens United and some of the subsequent cases, the court seems to be saying that there seems to be some philosophy on the court that perhaps maybe all speech should be unregulated, and there should be no rules on campaign speech at all. So I'm saying that there is a caveat there. I think we can do it. But that doesn't mean that the courts may not move the ball from where it currently is.
Steve,
To where we end up just creating a full employment act for lawyers.
There could be some of that, yes.
Carlo?
I'm just going back because it's one way ahead of me. The same thing applies to Broadway Theater as Theater Works, right?
We don't know yet. We haven't got to that page.
I think that is a question that the council would have to resolve, is it would apply, and keep in mind, we're talking about having to deal with this as part of a contract provision. We can't impair the existing contracts. So this would also be something that even if you adopted the policy, it would be included in the next contract, not existing contracts, because we can't impair an existing contract.
Now, you're saying Theater Works can't contribute, but the board members can.
The board members can.
Now, that apply the same thing as Broadway Theater?
That applies to Broadway theater, it applies to everything.
Okay, thank you, that's what I want to know.
Bill, Lieutenant?
Thank you, Mayor. Jeff or Steve, in the staff report, it says agency officials, and the definition says executives associated with defined affiliated agencies can be restricted from, and you say holding mayor and council member positions in the city, contributing city elections, contributing city and council member activities, and contributing to municipal ballot items. I understand the last three. I don't quite understand the first one. And my question is, what is who are the defined, the not-for-profits that are in the defined affiliated agency? And I'm asking that because every year we see in excess of, the not-for-profit committee sees in excess of 75 not-for-profits, all of which are 501c3s, making presentations, and the city grants them anywhere from $1,000 to $100,000. And the people that present to us are typically board members, executive directors of the organization, grants administrators, those types of people, all of which I think are very talented people. And in my opinion, could certainly hold mayor or council member positions in the city. Are you suggesting that they not be allowed to hold these positions?
Mayor, Councilman Patena, the answer is no. I don't believe you could do that for all not-for-profits. I think that would be, as I mentioned earlier, so constitutionally overbroad, it would not be sustained by the courts. Because many of these not-for-profits that come before the not-for-profit committee, the city funding is 1%, maybe half of 1%, maybe a quarter of 1% of their total funding. The city's interest there is not sufficient to allow you to do that. You would have to, it would have to be in your definition an agency where that you have a very significant financial relationship with. And then keep in mind the issue isn't whether they could hold the position. Of course they can hold the position. The issue would be then once they take office, if they remain with the agency may be in violation of their contract provision. The council cannot, this council nor any council cannot pick out and say, well, this group of people cannot hold office. They can of course hold office. The issue would be whether they'd be in violation of their contract provision.
Mr. Rivera?
Mr. Kemp, I want to go back to your caveat in regards to how the courts could be moving in a different direction. Whether intentional or not, what you just expressed, hope it's not trying to shape whatever council's action is going to be. And what I mean by that, because wouldn't that caveat apply to any legal advice that you give this council? Where you could be saying, hey, council, you're covered, but truly a judge could do something differently?
No, Councilman Rivera, the reason I made the mention of that point is because campaign finance, and in particular the issue of restrictions, is something that is extremely active in the courts. I can tell you, even in the Arizona courts, there have been a number of cases. In fact, I'm involved with one on behalf of the Attorney General's office. So there's just a number of these cases working their way through the court. And so the reason I mention that caveat is unlike many of the things I discussed with you, where I can say the law is pretty well defined on this. This is one area where I have to tell you the law seems to be moving. I can't tell you as a lawyer how it's going to look. All I can tell you is the sheer number of decisions say that courts are moving. If you look at Citizens United, which happened in 2011, virtually all 11 circuits of the U.S. Court of Appeals have had campaign finance cases. That's a very unusual thing on a topic, to have literally all 11 circuits have
But my
cases.
point is, even on sound legal recommendations, there's still that caveat, Steve.
There's always a caveat that the law can change. I just think here it was important that you know that the law seems to be moving much quicker than it might be in other areas.
Done? Mr. Toma?
Thank you. Mr. Kemp, I've dealt with attorneys now for quite some time, and I can tell you they've never guaranteed me a single thing, nor will they ever agree to. But I totally understand where you're coming from and appreciate that. Going back to Mr. Porteno's point, I wanted to make sure that I'm understood. I think my opinion is here that this would not cover all nonprofits, that it is not my intention to limit their activities in the city. As a matter of fact, I think virtually all of them do a very good job, and we should help them whenever we can. That said, so because of that, I should say, I think the limit should be that it should be these partner agencies that get a significant amount of their budget from the city. And so because of that, I'm proposing also that we maybe put a dollar limit, say everything over $50,000, which becomes significant at that point. And I think it would eliminate virtually everyone on this list except maybe 3 or 4 agencies. So that's what I'm proposing we do, and that we limit the restrictions to, again, people that have a financial interest in these 501c3s, not people that are on the board that are donating their time or that are leaders in our community. That's not my intent at all.
Okay. We're asking you to go over some of this again. All right, you're talking about the partner agencies that receive 50K or more.
Correct.
Now, let's go back to the restrictions. What restrictions are you recommending?
I'm actually recommending only the first 2, holding,
Holding office and contributing to the city elections.
correct.
Okay. Mr. Rivera.
Can you go to bullet number 4, the compliance?
Yes, sir.
I don't want to get off topic, Mr. Kemp, in this area, but this hasn't been discussed in regards to complaints. Shouldn't we put in, or should we put in some language in regards to complaints that have no merit, so we're not wasting people's times? Or how-
I think Mayor Council, based on your direction, will obviously have to draft this policy, and we certainly, what I would normally do with any complaint, and we can certainly have that kind of language here, which would be that we would do what we call reasonable cause analysis first, which is we look to see if somebody, it's just like with campaign finance. I get campaign finance complaints that someone's complaining, but there's nothing really there. There's no reasonable cause to believe someone violated the law. If that's the case, obviously, we would dismiss the complaint, and we could certainly incorporate that language should council decide to go ahead with the policy.
Good with that? Any other questions or comments? Then we'll try to summarize.
The one thing, if you would, the one thing we didn't talk about is enforcement, and I think probably everything on that list seems fairly reasonable. I'm not sure what the rest of the council, actually except the 3rd. I'm not sure that that's pertinent to this from a practical perspective, because again, we're talking about restrictions on individuals, so auditing an agency's financials wouldn't reveal anything to you about a personal contribution, is that correct?
I don't think it probably would, Mayor, Council. It would seem to me that maybe the better approach here would be to treat this somewhat like we treat governmental contracts where we impose a conflict of interest clause. In all city contracts, there's a clause that if there's a city employee involved in the negotiation of that contract, the city is able to cancel the contract without penalty. And generally, in most of our contracts, we also have provisions where if there's certain violations, the city is able to withhold payment under those contracts. And it would seem to me that those would be the two primary enforcement mechanisms. I'm not sure the city is quite honestly equipped to do extensive financial review and audits of outside not-for-profits without additional resources. And I think the first two would be the enforcement mechanisms.
I have a problem with this. If the CEO is the one that does the violation, you're punishing the organization. Now, generally speaking, these are organizations that do good for the city. Is there any way to, instead of punishing the organization, punish the individual?
That is a very good question. I mean, the difficulty here is,
Is there a fine that, could we levy a fine?
essentially, the basis for the city's actions are the contract not between the organization and the city. So it's much like when we have a construction contract, in fact, I can think of one, where the owner of the company may have done some things that we did not appreciate, but we really have no jurisdiction over the owner of the company. The entity we have the jurisdiction over is the company in which we contract with. And here it's the same thing. I think it becomes, constitutionally, I can't think of a way that we can, just sitting here, I'm happy to research that question, and I'm happy to report back, but I don't think that there's a way we can, because our contractual relationships with the entity, not the individuals.
These are organizations that work for the city in some cases, like the Diamond Club.
Yes.
And in a lot of ways too, like the Chamber of Commerce. And to punish the organizations because the individual CEOs, wrote a check to somebody, that doesn't work. That doesn't work for me. I don't see taking away the contract for all the guys that park cars out here during spring training because the CEO donated some money. I think that's foolish. I think that's dangerous for the city to do that kind of thing. Who's going to then park the cars? Because spring training is going to continue the next day.
I suppose the other way that we could approach this, Mayor, Council, would be to include as the penalty for enforcement would be that if there was a action in violation of this policy, that the city and the company would agree that the city could impose a financial penalty, but again, it would be against the company because that's who our contract is with, not the individual.
Well,
And that's the same problem.
but I could live with a financial penalty to the organization, but contract cancellation? Let's get a 45 and shoot that fly.
And
If I may,
That's insane.
what are the, it's a 3-time fine, correct, for a contribution or for a conflict,
It's a what?
mistake, if you
under
will?
the campaign finance law, generally certain types of improper contributions result in a penalty that is 3 times the amount of the contribution.
So can we suggest then that if it is a financial contribution issue, violation of this, if you will, that we would impose a 3-time penalty?
A penalty of, in essence, 3 times the amount of the improper contribution against the entity for which the person is the chief executive officer, whatever their position is.
Okay. And that leaves open the question, though, what happens if the ladder is broken, meaning the latter point, which is that they say hold office? What would happen in that case? 'Cause
If
there's
they
no
hold
fine there.
office, well, then I think the issue, in holding office, you cannot prohibit them from holding office. So then the question would be, again, our contract is with the entity. I think the city would then be faced with the position of saying to that entity, if your chief executive officer is holding office, they're either going to have to resign from you and you keep your contract, or if they insist on wearing both hats, then the city is going to look at canceling the contract. I mean, I don't see any basis that you can penalize someone for holding office. I think the only remedy is for them to make a choice which one is they're going to do.
So absolutely, then, my point originally was, everyone has the right to hold office, everyone has the right to be employed, any place that they choose to. But there are some situations where there are conflicts of interest, and this would be one of them. So the proposal then would be, and these organizations have boards of directors, and especially for those types of reasons, to ensure that their executives are doing the right things for that particular charity. So in this case, Bob, I submit then that we go ahead and do a financial penalty if that's the violation. It would seem to me then 3 times would be normal. It's exactly what campaign finance is. So I would say we would line with that. And then if it comes down to a violation where it's an office holder situation where they're both, then their options are you resign one or you resign the other, or the cancellation of the contract.
I can go halfway, not the second half. If you're holding an office, you would recuse yourself from any dealings with the city. But to force somebody to resign from an elected office because they made a campaign contribution, again, seems to me overkill.
No, I'm not saying that right, I'm talking about holding office, meaning that they violate that portion of the contract provision, not that they've contributed. If they've contributed, then the I guess the penalty, if you will, would be simply a 3-time.
Right.
Right. But if you were, say, elected and you're the director of ABC 501c3,
ABC Partner
sorry,
Agency.
too many codes
Let's just
here.
call it ABC Partner Agency.
501c3s, right. If you're a director of that and you get elected, then in that case, our only option would be to either have the director end his association with the ABC, right? Or,
Why couldn't you then still impose the 3 times the fine?
Well, I don't think, Mayor,
Because you're imposing
Council.
it on the director, you're not imposing it on the office holder.
No.
What would the
The
fine be
issue
based on?
would be that you'd be essentially punishing a person for holding office. I don't think constitutionally, I don't believe that you could sustain financial penalty on someone for holding office. I think in that case where a person who's a general manager, executive of an entity that is subject to this provision in the contract, when they took the oath for city office, essentially if they refused to resign their position, that entity would be in violation of the provision, and then the city would have to impose a penalty on that entity, which again, the question is that if you wanted to impose a financial penalty, I suppose you could do that. I'm not sure how it would accomplish anything though, because what happens if the person says, okay, you're going to impose a penalty of $500, but I'm going to continue holding both seats. I'm not sure I'm not sure how that would work. I mean, we could in theory do that, but does that really get to solving the problem?
right, right.
Well, even if you're not an office holder, you get the 50,000, you violate it, you're going to fine the company.
Yeah.
What's the difference?
The-
Because if this person does it repeatedly, obviously, the nonprofit would then remove that individual.
Yeah.
Because it would get expensive.
And you could
But
certainly.
what difference does it make of the job, any other job, that person holds?
So
The
what you-
violation was as the 501c3 executive officer.
So what you'd be envisioning would be that if they actually then took oath of office, the city might impose an ongoing penalty of so much against the not-for-profit until they either left office, and until the not-for-profit got back into compliance with this term.
Whatever,
I
I'm going to
mean-
vote against this anyhow. I don't care.
I'm just,
This is a solution in search of a problem. It's going to become a full employment act for attorneys. It's going to end up in court, and I suggest before you draft the policy, you talk to Dan Barr.
Yeah.
Anything else?
Ron?
Ron?
Are you aware of any such drafting that's been done by other municipalities or government entities, either in our state or elsewhere, that
Mayor, Vice Mayor,
restrictions like this?
Council, there's been, for example, the state of New Jersey has a law governing this, which mandates that all local governments have to adopt their own contractual provisions. And there's other cities across the country. I think the key, as I mentioned, the key points here will be, is there a compelling state interest? I think the compelling state interest does exist to some degree to avoid conflicts where the city is a substantial funding entity. Then the next part of this is, what's the least restrictive means? And that is where these policies, and there's been litigation over these policies. There's Securities and Exchange Commission policy has been litigated, and so the answer is yes, there's policies across the country, and yes, there's litigation over them.
Over there.
Yes.
Thank you, Mayor. So Ben, let me see if I understand this correctly. We're throwing around a threshold of about $50,000 going to a defined affiliated agency. And I'm assuming that you feel that they shouldn't hold an office primarily because you see that as being a conflict of interest, correct?
Correct.
Okay. So then I'd like to ask Mr. Kemp as a follow-up question, no matter how much we give an agency, 50,000, 100,000, do you see, or I'd like an opinion, do you see a conflict of interest there?
Councilman Patel, members of the council, in terms of Arizona law, the issue of conflict of interest really is, it doesn't have to do with how much you give the agency. It has to do with whether that agency executive, well, now that they're a public official, is receiving a substantial benefit by virtue of the decision they're making as a public official. A substantial benefit is any monetary or pecuniary benefit. So if they receive a benefit of $100 and it's an actual monetary benefit, that's a conflict of interest under Arizona law. The Arizona conflict of interest law doesn't, it looks at simply whether it's an actual monetary or an actual pecuniary benefit, which would be something more intangible, but still a direct benefit. And it says if you receive either of those, or if a direct family member receives either of those, you have a substantial interest in the matter, and if you participate as a public official, then you've engaged in a conflict of interest.
So if part of the money that the city gave the agency was used for the executive director's paycheck, that would be a conflict of interest?
I think the issue there would be the executive director of Day One Council would have to recuse themselves from that agenda item under Arizona law, because for them to vote on that agenda item, they have a direct financial benefit. And so they could not participate in that contract. If, for example, the city awarded a contract to ABC, not-for-profit, it has nothing to do with the executive director's salary, it's going to provide them a new building. That would not be a conflict. But if the contract did provide funding for the salary, yes, they would have a direct financial interest, and they would have to recuse themselves as a public official from participation in that matter.
I'm good. Oh, go ahead.
I'm sorry. So, Mr. Kemp, two points. First of all, we talked about originally, I think, couple meetings ago about the IRS's potential interpretation of this situation, where 501c3's executive of any kind that would also potentially hold public office, and there are, if I'm not understanding, if my understanding is correct, there should be no political involvement whatsoever?
Yes. The tax code is a totally different thing than what we're talking about here. Under the Internal Revenue Code, there are different classes of not-for-profits. One that you've probably read about recently in the newspaper is 501c4s, social welfare organizations. They can engage in political activity as long as it's no more than half. 501c3s, which is the more traditional form of not-for-profits, are not permitted to engage in political activity at all. They can engage in educational type things, such as, yes, we're going to have an election, you should do your civic duty and go out and vote. But they cannot engage in political activities. To do so would be a violation of the Internal Revenue Code. Now, the only entity authorized to enforce the Internal Revenue Code is the Internal Revenue Service. We, the city, nor the state, nor anyone else would enforce the code. But conceivably, an office holder continuing to serve as an executive director of a not-for-profit, could well run into issues with the Internal Revenue Service. How much the service would do with that, anyone's guess.
But, Mr. Kemp, if that were to be the case, and say it's someone that does a significant service, an organization that does significant service for the city, would that not put us in a very precarious position, shall we say, if the IRS automatically revoked their 501c3? I'm sorry.
I think the issue for the city would be certain not-for-profits serve our purposes only if they have a 501c3 certification. So then the issue would be if the Internal Revenue Service revoked that certification, the council would have to make a decision, why would it want to continue having that relationship with that not-for-profit? For example, some not-for-profits are able to sell tickets for entertainment events not subject to state sales tax under the state's tax code, and they have to be a 501c3. If that not-for-profit lost its 501c3 status, it would no longer meet that provision of the state sales tax code, and if it was selling entertainment tickets, those tickets would become taxable. I would think at that point, we would certainly come to the council and say, okay, council, what do you want to do?
Let me see if I can get consensus here. Your proposal is the agencies that receive 50,000 or more,
That are also partner agencies.
partner agencies.
Right.
The office, they cannot, the CEO or chief officer, whatever the title is, cannot hold office. In terms of the investigation, they would apply the reasonable clause.
Yes.
In terms of investigations. Conflict of interest would obviously come up periodically. And if they're found to be in violation, there would be a financial penalty 3 times the amount donated.
If it's a financial contribution, yes. If they are holding office, then the contract would be canceled.
Okay. All right. Oh, yeah, and the city attorney would be the investigating agency, so to speak. Does that cover
Yes.
everything? Yes or no?
Yes.
I don't think so.
No? No. So we're done with this.
I want to discuss it more.
I didn't mean to cut you off, but we got a bunch more to go.
I wasn't clear on what you said, Steve. You said if a person is holding office and then they vote for something in terms of the agency that they represent, that's not a violation unless they're getting money. But I don't think that's true. If they benefit their organization, I think it's a violation because that
Under the Arizona
advances the meaningfulness of that organization. So I don't think they should get to vote on really anything related to that.
Well, under the Arizona Conflict of Interest law, if a person, for example, is a public official and they vote and they have a direct financial benefit, that violates the law. Now, if it happens to benefit their employers, but it doesn't, they don't get a direct financial benefit. The classic example is somebody who's on a city council, they work for a landscaping firm. And they get no benefit from it, they don't get a salary off of a contract, and the city awards a contract to trim trees. They have absolutely no benefit, but the company they work for does. Is that a conflict of interest under Arizona law? No. They have to receive a financial benefit.
But if they're the CEO, then
If they're the CEO, I think then they would, the issue there becomes, the higher up the ladder you go, the more that there's a benefit here. The difficulty is in Arizona, it is a case-by-case test. So, I mean, I suppose if you have a very, very small company, 2 employees, and you're the CEO, there's going to be more things that happen in a decision-making process in a company where if you have 100 employees and you're the CEO. And so that's going to be one of these where it's just the nature of the size of the company versus, and where
and
the
the
person is.
responsibility of the company.
And the responsibility that they have. But merely the fact that a company that you work for receives, is in front of the council, doesn't necessarily mean you have a substantial interest in it. That would create a conflict under Arizona law. It would be, it depends, as a contract professor once said to me. We'd have to look at it.
Okay, and I think you asked us to nod, but I wasn't sure because we had a couple of things we were discussing. And on the agency officials, we had holding mayor and council member positions and contributing to city elections. I think contributing to city elections, I think we should look at that 3 times there for that, but not the holding office.
I'm not sure I understand what you just said.
Well, and we didn't go through the whole thing either, agency definitions, and we had agency activities, and we said all of those were,
Can you put up agency activities? We can't do any of the restrictions on agency activities.
an agency if it
Because
if
that's-
it had a PAC or something like
That's
that.
already by law, that's done by.
Right, I understand that, okay. And then we went to the next list, and we felt, contributing to city and council member activities and contributing municipal ballot elections, we didn't want to put restrictions on those, right? But then we were talking about restrictions on holding an office and contributing to city elections, so,
And that was in this policy.
And again,
Proposed.
yeah.
so council understands how that in reality would work, is that if an individual contributed to the election, it would be in essence a violation of the contract terms between the city and a not-for-profit, which would lead to the imposition of the financial penalty. It's not that the city can say, you're a member of a you're an executive director of not-for-profit X, you shall not contribute. It is that the city's going to impose the financial penalty.
I understand that, and I think certain not-for-profits may prefer certain council members versus others, and those directors may give those council members money and not other council members, and I think there should be some restriction on that. So,
If the CEO gives any council member
Yeah.
a donation.
Then it
that-
would,
That is, then somebody complains, they'd go check it on the reasonable clause routine, and then they determine whether or not that's a violation.
yes, in essence, how I would envision if council ultimately enacted a policy, this would work, is somebody would file a complaint, it would be looked into, and it'd be determined that the executive director of ABC not-for-profit made a contribution in a city candidate election to candidate 1. Then the not-for-profit would be notified that pursuant to the terms of its contract, the city is imposing a penalty 3 times the amount of that contribution to not-for-profit 1. and we would either withhold that funding from them or demand that they pay that. And then what would occur is if I would expect not-for-profit one would take their executive person aside and say, you just cost us this much money, don't do this again.
Yeah,
Clear enough?
Yeah.
but we said we weren't going to do that when you asked for a voting, right?
No, I said we were.
Well, we were going to do
That was part of this
contributing
policy.
to city elections. Oh, okay. But not holding the mayor or,
Well, yeah, and if the mayor is also the CEO who makes the contribution, the mayor might have to resign. Or resign from the not-for-profit. Either quit his job or quit the office.
but I want to vote yes on one, but not the other, so how does that work? So we can bring that one up, huh?
What'd you have?
Well, you know, looking at this, I understand that there's a legal issue here, potentially, and I understand that the restrictions on the legal side are not necessarily that, the conflict of interest is fairly narrow in the way
Yes.
it's defined legally. But from a practical perspective, you know, looking at this, I think any financial conservative, if you want to call yourself that, would have to agree that getting a double paycheck, if you will, from taxpayer funds, because these, if we're talking about organizations that receive the majority of their funding from the city, and they're also paying these individuals, because again, the restriction would be for paid individuals only, and these individuals then get to sit on this council and vote on whatever we give them to
They
the
wouldn't
same
vote,
organizations.
They'd have to recuse themselves.
Okay, so even if they recuse themselves,
The law is there already.
even if they have to recuse themselves from that particular vote, the reality of it is there's influence that can be exerted on other council members here. So to me, it just doesn't pass the reasonableness test at all from a, again, fiscal conservative perspective. So if you disagree, that's fine. Everybody has a right to do so. But I just don't see from how you could define this anything other than essentially a double paycheck.
Did you want to change your vote?
Well, just in terms of the contributing to city elections, yeah.
No, this was the proposed,
All of it, all of
Yeah.
it.
Right. Now, we can
Can I-
always come back to it again later.
Bob, can I
But-
recap?
No, you can't. Do you want to change your vote?
Well, I guess so, because I want to do part of it.
Okay, so you want to approve this? Because then when it comes to council, you can take a piece out or stick a piece in. Because it has to come back to
'Cause
council.
we're not actually voting on it.
No, what we are voting on is whether or not we want them to go write the policy and bring it back to the council for discussion and a vote.
Okay, I would like to see the full policy.
Okay, see the policy. Now it's a 4-3 the other way. So you want to develop the policy and then bring it to us for a vote.
Thank you, Mayor.
You're welcome. Number 3.
The next item coming to council study session for discussion is also an item that's coming back to the council from some previous conversation that you had, and this goes back maybe a month or so ago, and it has to do with an item that was brought up by Councilmember Rivero, and it is with respect to possible changes in the procurement process. And well, at last time when the council discussed this, it was coming to you from one of your policy committees. The council had requested that it come back in November. That was requested by Councilmember Rivero to occur earlier, and that is why it's before you this evening. So with that, I'll turn it over to Brent Mattingly, our Chief Financial Officer, for a brief presentation.
Thank you, Carl. So you may recall that back on April 21st of 2014, Councilman Rivero had submitted a request that a council subcommittee be provided with an overview of the city's procurement process. So staff met with that subcommittee on May 21st and gave that overview. At the conclusion of the subcommittee meeting, the council subcommittee gave direction asking that staff look at the procurement practices and processes of other cities in the valley and to bring that information to the full city council in one of your regular study sessions. So we did that. On August 27th, staff gave a presentation on our procurement processes and practices. We explain that other valley cities have procurement processes and procurement codes similar to Peoria's. Our presentation included some charts highlighting the similarities and differences between the various cities, and we talked about bid preferences in valley cities and some of the legal implications of that. At the study session, we also went into some level of detail discussing the similarities and differences between specifically the city of Peoria and the city of Phoenix. Some of the items we talked about between Phoenix and Peoria was whether each city had a procurement code. So we talked a little bit about that. We talked about bid thresholds for obtaining just informal quotes versus a full formal procurement process. We talked about dollar limits on job order contracts. We talked about the council approval process for contracts. And we talked specifically in some depth about the use of council subcommittees in the city of Phoenix for certain solicitations of interest. So as we discussed, the city of Phoenix takes certain higher profile and significant solicitations to a council subcommittee prior to issuing the RFP, the request for proposal for firms to respond. And at that subcommittee meeting, the City of Phoenix staff discusses things such as the purpose of the solicitation, the specific goods or services being procured, perhaps the evaluation criteria that are going to be used, the method of delivery of the contract, and any other relevant information. Typically in Phoenix, after it goes to the subcommittee, the final results of that solicitation process. So, firms have now responded. A staff committee has reviewed all the proposals, evaluated them, ranked them, and they've come with what their recommendation is going to be. In the city of Phoenix, they will go back to the city subcommittee and explain what they're going to be recommending to the full council for contract award. We also learned, subsequent to talking with you, that Phoenix also allows, instead of going to a council subcommittee, staff may say, this particular solicitation might be of some interest, and if the staff wants to, they can put that solicitation prior again to issuing the RFP on a city council meeting consent agenda. So all the city council people see, okay, staff is going to be issuing a solicitation for such, XYZ service, and if a council member is interested, they can pull it off the consent agenda and then the full council can talk about it. So that there's really those two alternatives in Phoenix. Either, as you see on your slide number 1, the staff report is placed on a council consent agenda, or the staff report, again, goes through the subcommittee process that we spent some time talking to you. Phoenix also told us that about 8% of their solicitations are previewed by the city council prior to issuing the solicitation in one of those two ways.
Question? Again.
Are you saying it could be either or here?
I'm sorry?
Either or we're just supposed to pick one, or what?
No, it happens both ways. It could be
Both ways.
either or.
Okay.
Either or, okay? When we were talking,
Before you go on, let me see if I got this right. Let's say you're talking about tire providers for vehicles, and they would put something on a consent agenda saying they're going to go out and ask the tire manufacturers to bid. Is that, and then they could pull it off? Is that what you're saying?
yes, and they could then
Go to the
give
subcommittee.
any input that they might have into their view on that solicitation prior to issuing the solicitation. So, for an example, rather than, we were told that it happens more often with service-type contracts in the city of Phoenix. So an example that they gave us was the janitorial contract for the city of Phoenix airport went to the airport subcommittee to talk about that solicitation prior to it being put on the street for firms to respond. I don't know the nature of that council subcommittee conversation, but probably the types of things that I just kind of went over, how we're going to go about issuing it, what are the evaluation criteria, those types of things.
So they talk about what the parameters of the RFP would be.
Yes. Phoenix also told us that this process of going to a subcommittee or going to the subcommittee prior to issuing the RFP, going back to the subcommittee after the results come in, and then placing the contract potentially on a city council agenda, probably adds on the average about 1 month to 3 months of time to that solicitation process for those 8% of the solicitations that go through that process. So at the August 27th council study session, your direction was for us to bring back the changes that would be necessary if the council were to decide that the city of Peoria should begin following all or some of the city of Phoenix procurement process of specifically bringing those higher profile solicitations to a city of Peoria council subcommittee, or perhaps placing it on a consent agenda like they also do, prior to us as Peoria staff issuing that solicitation. So to follow up on that, your agenda packet this evening includes a red line version, blue line version of the current council, City of Peoria Council Subcommittee policy that includes the changes that would be necessary if the council were wishing to do that. So the primary change is that as you recall, when council subcommittees were originally formed, they were designed to address policy issues. And so that the current council subcommittee policy talks about that. It says policy issues will be identified and brought forth to a subcommittee and tells how that's going to happen. So the city attorney's office simply broadened the definition of policy to include and procurement items, to broaden that definition that would allow the current council subcommittee to be used. We don't believe that any changes would be necessary to the City of Peoria procurement code in order to enact this if the council decides to do that. So again, the main change is broadening what policy means in that document. Under this, either similar to Phoenix and similar to how we do things today with our subcommittees, either a council member or the staff could place a solicitation on a particular subcommittee for that process, or staff could place a solicitation on a consent agenda if we thought it was a significant one that you might be interested in. If council adopts this change, what the City of Peoria finance and budget staff would have to do, and we can do this, would be to notify the city council of upcoming solicitations as soon as we find out that it's going to be something that we're going to start working on. So, you would need to know what are the solicitations coming up, and so we're going to have to figure out a way, and I think we could do that, of notifying you either really early on or sometimes just as soon as we find out from a department that they want to start working on one, we could let the council know which solicitations are coming up. So that would give you an opportunity, if there was one of interest, to again follow that revised policy and identify that for us. The other change that I think is important also that is included in your draft policy is, and you'll recall this, that if an item goes to subcommittee today under your current subcommittee policy, unless it's of real time sensitive of a nature, the items that go to a subcommittee must go to a full city council study session. That is different than the City of Phoenix model for their procurement items. And so again, the city attorney drafted language that would allow that step of going to the full city council to be eliminated for solicitation items. You know, so that's for your, again, for your consideration. I'll talk about that in just 1 second. So as I was thinking through this, I would suggest that there may be kind of a series of sequential questions that might help your conversation tonight. And let me, before you jump into them, let me just kind of walk through them really quickly. So the first question, what seems to be whether Peoria, in fact, should implement Phoenix's practice of engaging council in the review of significant solicitations prior to the solicitation being issued. So that's probably the first question that would be good for you to decide. If you were to suggest yes, then the second question asks if, similar to Phoenix, should Peoria allow the option of placing a solicitation either on a council consent agenda or taking it to a council subcommittee? The third question then says, if a significant solicitation goes to a council subcommittee, should that subcommittee review of that solicitation occur prior to staff issuing the solicitation? Should we bring it back again after the solicitation results come in, like we understand the City of Phoenix does? Or do it at both, do it before, do it after, or do it at both times? And lastly, if a solicitation does go to a city council subcommittee, would that solicitation also have to go to the full council prior to being issued? And as I said just a minute ago, Phoenix does not require that specific step. But again, this question is raised because your current council subcommittee says if something goes to a subcommittee, it has to go right now to the entire council unless it's of a time sensitive, and unless the timing is critical having to do with that. So I guess my suggestion would be, if you wish, start at the top of the list and have your conversation about what you want to do with
Okay, I have a couple of questions first. You keep talking about a significant solicitation. Is there a monetary value that you're talking about? Is there a ceiling or a bottom? If it's X amount, it has to go through this process, but if it's below that, it doesn't go through the process?
There's not a-
Or is this all solicitations?
It could be any solicitation. Again, what we heard in the City of Phoenix is that they tend to be the more significant, important, broad, large, service-type solicitations.
But there's not necessarily a number attached to
There's
that.
not a definition or a
It's
number.
not like all solicitations over 50,000 have to go through this process.
No, sir.
Okay, the second question I have for you is, and maybe it's for staff, is if you come to the council and tell them about the solicitation before it becomes public, is that detrimental to the city? If they go along and they tell their buddies, oh, guess what, I got one coming up that's in your business.
I don't think so. One of our principles really is to try and encourage people to participate in the solicitation process. So hearing about a solicitation is a good thing. We try and actually advertise solicitations and inform companies, this one, you may be interested in. We want that competition.
Okay. Does anybody have a general question before we start going through that? Go ahead, Tony.
Mr. Mattingly, I had a concern from a citizen, and his concern was that this subcommittee change would handcuff staff's hands in regards to sending out an RFP, or if we needed to do something in an emergency mode. Does this handcuff the city of Peoria?
If it's a true emergency, there's language in our procurement code that lets us deal with that. I wouldn't say it handcuffs us. I think, it will take longer to get through the process for those solicitations that would go through summer, all of this process.
But in a situation where we need maybe a contractor, maybe a lobbyist, would this, in an emergency mode, would we would this stop the city from being able to hire someone?
Well, when I was saying emergency, I meant something health, safety sort of thing. So, other types of contracts for, what was the first one you
Well,
said?
let's say there's something that comes up
Yeah.
that needs to be dealt with in a very sensitive, timely manner.
We're required to follow our current process if it's not an emergency. Again, if that particular solicitation was identified to go through this process, it will take longer. But if it was not identified to go through this process, we'd follow our normal steps.
Okay. In regards to number 4, and I just want to provide my opinion, I don't think if the solicitation goes to the subcommittee, I don't think we should be required to go to a study session. It could immediately go out to the RFP. And in regards to whether council knows and they're going to spread the word about an RFP, well, staff is going to know already. They could spread the word on the RFP too, Bob. So.
Done?
Yep.
Mr. McKenna?
Thank you, Mayor. Give me an idea of, and I hate to generalize this, but give me an idea of Brent, of, right now, if it goes to subcommittee, it has to come to a study session. What would we as a council be discussing about a solicitation?
Maybe, this is hypothetical because we haven't done this. Let's say that let's use the City of Phoenix custodial contract at their airport. And again, I'm kind of making this up because they didn't give us specifics of that. But certain council people may, from their experience, feel that the level of custodial care in the restrooms isn't nearly as great as it is in, the food court, or maybe in Terminal 2, the custodial care is really lacking because most of the traffic's in Terminal 4, and it seems like they're focusing on that, and they might say, we need to make sure that there are performance criteria terminal by terminal, so that if they're not doing a good job in Terminal 1 or 2, we have the ability to make sure they increase their level of service, or
And so how do you feel, say, going to even a subcommittee, and perhaps, like Mr. Rivero said, not coming to the full council? How will that affect, in your opinion, the efficiency of our current procurement process?
Well, the efficiency will suffer a little bit in terms of the timeline. I think, as we shared with you in one of the other study sessions, our track record is pretty good in terms of issuing solicitations, getting firms to respond, getting a good level of service, and not having protests or problems with the contracts that we put in place. So, from my perspective, I'm not sure where I would see an increase in efficiencies by doing this.
Mr. Ames?
Yes, and I think we are talking about, because you mentioned service at the airport, so certain council members may have things that they've learned from citizens that are problems, and they want to make sure they're in the solicitation and addressed, that, maybe the staff hadn't heard about. So, I can see where there would be things that council people may want to recommend to include in the solicitation as criteria. Also, I don't think that, the timeline, you're going to have this, so you can start things a little earlier too then, right? Because it's part of the process now at the front end.
Well, we tend to start the solicitation process as soon as the need is identified. So if there's a department identifies the need for a service that requires an RFP process, we would get started as soon as we're aware of that need, working with that department. The timeline, I think, that Phoenix is experience is simply getting it on the agenda and getting it in front of those committees and through the process. I mean, it does seem like it would add some time to it. They estimated that that was between 1 and 3 months on those types of solicitations.
Thank you.
John?
Thank you, Mayor. Brent, how many solicitations do we have on a monthly basis?
Okay, so we did have an email that I'd sent out to you, and I think I have that slide that might answer your question here. Great. There it is. So these were some statistics that we pulled together. There were 183 contracts, so there would have been likely a solicitation for those. 30 of those went to a city council meeting, so about 16%. The dollar amount of those 183 contracts was $73 million. So 31 million of it, or 42%, went to council and was approved. So to get to your question, how many solicitations do we have? Maybe it's a close enough number to say, you know, there were 200 for that period of that year. Does that?
For a year?
Yeah, is that close enough?
I'm just looking for kind of like a monthly average.
Okay, so 10.
So if
15.
if you came to us on a monthly basis and said, these are 10 contracts that are up for renewal or solicitations, and we're going to put them on the consent agenda, that would give an opportunity for a council member to be able to pull that up, or pull that off, or request it to be pulled off, and then be brought to council for discussion. Is that correct?
What my
If that's one of the options? Or
Yeah, the city of Phoenix does not put all of their solicitations on. If a council person in Phoenix says, I'm interested in that solicitation going to a subcommittee, only that one would go to a subcommittee. If staff identified one that they thought a subcommittee might be interested in, that one would go. If staff identified some solicitations, not all of them, but some of them that they thought would have potentially some council interest, staff would put those on the consent agenda. So in this case, out of the 183, the only ones that would go to a subcommittee would be ones specifically identified by a city council person or staff. The only ones that would go on a consent agenda would be ones, using the Phoenix model, identified by staff that a council person had not identified, that a staff person said, I think council might be interested in at least seeing this on consent. So only a few of the 183 would probably end up either in front of a subcommittee or on a council consent agenda.
Okay, thank you.
Other questions? I've got a couple concerns here. First of all, if it goes to the subcommittee, I would like for it to come back to the full council. I don't like the idea that 3 council members are going to make a decision to move this forward without discussion by everybody. The second, I would suggest we put a monetary level on it. You know, if a contract is not worth more than, what is it now, $50,000, is staff has the right to do that?
$50,000 is the limit that would require a solicitation to be issued.
Yeah, because that solves your problem about timing. Because most of those, like a lobbyist, you have to hurry up and hire. You know, staff would still have the authority to just do that, as opposed to having to go through the solicitation process. So I would think we'd want to put something in there, or maybe put a monetary value on there that if it's a solicitation of a given amount or higher, bring it to our attention. And then we decide whether we want to send it to a subcommittee and everything else.
Isn't that the case right now, 50,000?
Yeah, 50,000. Anybody else? No. So I would say this would apply, if we agree to this, this would apply to contracts only in solicitations, only in excess of 50.
And when we're procuring goods or services over 50,000, we always issue a formal solicitation.
Okay.
So every
we're already issuing formal that's all the solicitations.
But that's when this process would kick in.
It certainly could if that's what council wishes.
I'm sorry.
Yeah, I was going to say, unless staff felt they wanted to put it on the consent agenda.
Oh, yeah, any problem with that?
You had your
Mr.
concerns,
Rivera?
are you done? Yeah.
Go ahead.
I would like for there to be language in the draft. I'm not sure if you're drafting it, Mr. Kemper and Mr. Mattingly, in regards to what we just discussed about the 50,000. And if maybe on a monthly basis, council can receive the list of the potential RFPs that are going to go out.
It would definitely be more frequently than monthly because of how often we start a new one. We wouldn't want to wait a month. So I would suggest that if this is the direction you're going, that staff would on a regular basis, perhaps weekly, but when we felt we had some to let you know about, then the staff would let the council know of the solicitations that we're starting in your, that are over $50,000. And then that would be the way of informing the council. If you're interested in any of these going through one of the two processes, that you would let us know via currently filling out the same form that you would fill out to send an item to a subcommittee, that particular solicitation you would like to go to a city council subcommittee. We perhaps could also amend that you would have the option of, instead of sending it through the subcommittee process, say, I would like this solicitation to be placed on a consent agenda.
I think that I see, first of all, an efficiency problem. Plus, it could add, if we go to subcommittee, then ultimately to the full council, then you have a 1 to 3 month delay on the process, which is what is happening now in Phoenix. And what I was trying to get at with Brent was, when I asked you the question, what are we going to be discussing as a council? What we're going to be discussing as a council on a particular solicitation is the intricacies of that particular solicitation, and we're going to be ripping it apart to determine what's good, what's bad, whatever. And I see that as a council getting involved in the day-to-day operation of this city. And I'm not interested at all in getting involved in the day-to-day operation. I think that's why we have our staff, and you don't get a lot of protests right now from people that are trying to get jobs from the city and putting in contracts with us. And I'm just not interested right now in getting involved in the day-to-day. And I think that's exactly what would happen, is if we as a council started ripping apart these contracts that come before us, and I'm not interested in that.
Anybody else? Mr. Reeves?
Yeah, I feel, and we're doing it on a limited number here. I think it's important for the council to understand these contracts better than I think we have in the past, because they kind of come to us at a regular session, and we got to make a decision. I think if we're involved in an earlier stage, we'll understand them better, and I think that's good due diligence on the part of the council.
Mayor?
Go ahead.
I think if you look at the statistics, we're already almost at 50% of the dollar amounts that have to come before this council. That's half. I don't think we need to go beyond that.
I thought it was 8%. What's the? I know.
The city of Phoenix, about 8% of their solicitations end up going either to a subcommittee or on a consent agenda. I think Mr. Patena was saying that 42% of the dollar amount of the contracts entered into go before the city council in the city of Peoria. So two different statistics. 42% of the dollar amount of the contracts end up before the city council. 16% of the number of contracts end up before the city council in the city of Peoria. The 8% was 8% of the solicitations in Phoenix end up either
at a City of Phoenix subcommittee or on a City of Phoenix consent agenda.
But these current statistics don't mean that we're going to, every one of those 42% that come up, that we're going to ask to review them, right?
That's correct.
Yeah, so it is a much smaller number than you see. This is all of them that come, that we end up voting on, I guess, huh?
Those are the ones that, again, the 30 contracts for 31 millions are the ones that the city council specifically approved at a council meeting
Right.
in Peoria.
And that may be a similar number for Phoenix, but that doesn't mean that they actually have an input on them before, at the onset, which is what we're talking about now, right?
Input through the solicitation process, they would not have input on all of those, correct?
In fact, on a small number, actually.
Mr. Tillman?
Just so I can understand a little better, kind of along those same lines, when you look at the previous, I guess, the 8% that we were talking about before, that's different than this 16%, for example, which is number of contracts currently before this council is at 16% for this year period that you pulled. The difference there is that for those 8%, there's involvement from the beginning of the RFP versus this 16% is just sort of approval or discussion once the RFP is basically done and come back, and then we simply approve the final contract. Is that correct?
That is.
Okay, so
Yes.
there is a difference there. They're not really apples to apples, the comparison. It's a,
The 8% is a different number, right?
okay, got it, thank you.
Other questions? Okay, I'm going to take a shot at this, and then we can work it out again. Okay, first of all, we're limiting this to contracts in excess of $50,000.
Unless the staff wants to.
Yeah, oh yeah, unless the staff asks for something to be put on the consent agenda or whatever.
That's less than 50.
We're going to get regular, possibly weekly notices of solicitations that are being prepared. Then a council member can ask that it be either put on the consent agenda or sent to subcommittee and put it through the subcommittee process.
Yes, sir, through the normal process that you use today for your subcommittees, very likely similar to that.
Is that about it? Did I miss anything?
What, he had that list of 1 through 4 or something? Questions he had us?
Okay, I guess we are, should
Just
we
doing
implement
one.
the Phoenix practice first of all? Or portions of it, because they don't limit it to 50? Yes or no?
Yes.
Oh, that's a yes. If yes, then similar to Phoenix, should Peoria allow the option to place a solicitation on a subcommittee agenda or a council meeting consent agenda?
Is number 2, number 3 the same question?
No, number 2 is, can it either go to a subcommittee or go on consent? So I would suggest you figure that out, if both of those options are okay.
Both options?
Yes.
Okay. Okay. Third, if yes, then should the review be prior to issuing the solicitation, after the solicitation results are determined, or both?
That really refers to, if it goes to a subcommittee,
Right.
does the solicitation have to go prior to, should it go prior to issuing the solicitation, after the solicitation results have come in, or at both times?
Carla?
We haven't discussed this.
No, we haven't really discussed this all. Okay. Comments?
Okay, now we got another dimension here. This is after, this is a different,
Okay, so just as a recollection,
Did I miss
reminder,
something?
in the city of Phoenix, our understanding is that if there is a solicitation identified, let's say by a council person, that's going to go to a city of Phoenix subcommittee, in Phoenix, it's our understanding that that solicitation goes to that subcommittee prior to the solicitation being drafted or prior to it being issued. Then it's issued, firms respond to it, it goes through a subcommittee evaluation process, they get ranked, a top firm to enter into a contract is identified, and the results, therefore, of that solicitation process and the recommendation would come back to that same subcommittee. Subcommittee could decide certain things, I guess. And then after that second visit, the contract for that service would potentially be on a City of Phoenix, would likely be on a City of Phoenix City Council agenda for approval of the contract. So it'd go to the subcommittee before the solicitation is issued, go to the subcommittee after the results of the solicitation, goes to the City Council for award of the contract.
Yes.
Just before.
Both, yes.
Both.
I think just before.
Yes, well,
Yeah, what, before or both? It's both. If solicitation goes to a subcommittee, does the solicitation also have to go to council prior to being issued?
No.
Okay,
I thought this was referring to
It does.
going to council study session,
Yes, that's correct.
so there's no reason for it to come back as council study session. We just talked about the process coming directly to council, did we not?
This gets back to
I got
your
lost there.
current policy that except for critical time-sensitive issues, that all issues going to a council subcommittee have to go to the full city council for review. Number 4 is suggesting, can that not happen in cases of solicitations? And it simply, after the subcommittee sees it for apparently the second time, can it skip the full council agenda item, and then if the contract is required by our code to go to council, we'd put the contract on a council agenda. Otherwise, we would approve it the way we do today, according to our city code.
Just to be super clear, number 4, what we're talking about here is study session, not regular council agenda, correct?
Yes.
Okay, so if we're talking about a study session, then I think we've sort of agreed that we don't want it to come back to study session after the committee's seen it twice.
Do you want it to come back to study session?
Yes.
Ben?
No.
Yes.
It's no. Any other questions?
No, sir?
Anybody else? Okay. So you'll develop that and bring it forward for action.
Mr. Mayor, I need a clarification from staff. Who's drafting this?
Mayor, Council, I'll be working with Mr. Mattingly on redrafting the policy to have that come back to you at a subsequent agenda.
Okay, what's the time frame on that?
I don't believe the next meeting is until November 25th, so, and normally we would have this out to you, so we would look to have it at one of your next 2 meetings.
Okay, thank you.
P83?
Thank you, Mayor Barrett. The next item, and actually the next 2 items, are coming to you from the staff. They're both items that have been high priorities to the council, and we had committed to come back with you with updates and status reports. The first one is on the public improvements that are going on in the P83 area, and including the updates to our sports complex. Andy Granger will make this presentation. Andy?
Thanks, Carl. Mayor and members of the council, as Carl stated, this is primarily just an update on some of the capital projects that we have going on in the P83 Entertainment District. You're going to see a lot more activity going forward. We're starting our P83 Streetscape project, and we're also starting or undergoing some other construction projects within the district, and so this is what the presentation is about. Our first project up is our Skunk Creek Trailhead. That is it's going to provide a new connection to our New River Trail system. We are almost complete with the construction of this project. It's going to provide automobile, truck, and trailer parking, water, trash, and recycling receptacles at the trailhead, as well as a shade canopy with an overlook, which is a unique feature to this trailhead. It's going to allow visitors of the trailhead to be able to look at the unique bird habitat that appears at that overlook, as well as it provides equestrian facilities for people that want to use the trail for equestrian use also. We're almost done with construction. We should be opening the park or the trailhead up by the end of November, and we are currently under or will be within budget on this project. So you will see this opening up at the end of November. Our P83 streetscape project is currently underway. Starting today, actually, we saw some demolition at some of the corner treatments. They've got fencing around all of the corners, the major corners along 83rd Ave. So they're going to start the demolition of some of those fountain areas where we're going to have new corner treatments that signify the P83 and really give identity to the district. The project is going to also include wayfinding signage, raised landscape medians along 83rd Avenue, the corner treatments, which I just stated, a pedestrian Z-crossing between Mariners and Stadium Way to help pedestrian activity from the east and the west side of 83rd Avenue, as well as the P83 pylons. And on the right, you can see some of the renderings of the corner treatments and the Z-crossing, as well as the top picture is the kickoff meeting that we had earlier this month to kick off the construction activity and signify that the construction is actually starting. We had several council members in attendance at that kickoff meeting, and they were each allowed to utilize a sledgehammer and take a whack at one of the fountains that's going to be demolished. This slide just represents what we're going to see in the future. It's that we're going to have 22 pylons along the east side of 83rd Ave from the Skunk Creek all the way up to Bell Road. And so we went out and did a mock-up to make sure that what we were designing is actually going to look appropriate out there. So this rendering these mock-ups were put up on a lift to what the actual height will be. They're going to be approximately 23 feet in height. And they're going to have similar lighting to what you see here. This is so we had a mock-up of the top 8 feet of the pylons, and so that's what this shows here, and it gives kind of a perspective of what that will look like, the individual pylons along to increase the identity along P83. We wanted to give you an update on some of the other activities going on at the Mariners Clubhouse. They recently completed the solar system installation at the Mariners Clubhouse. This is unique to this clubhouse. It was an opportunity for the Mariners to enter into an agreement. They have an agreement with Samsung Electronics to utilize solar systems through that contract, and so we partnered with the Mariners as well as APS and a solar system provider to install a solar system at their clubhouse. It provides our clubhouse with equal to or lower rates than what our current APS rates will be and our future APS rates will be. And it also provides shade covered canopies at the parking area for the Mariners Clubhouse. It really meets our sustainability initiatives and provides obviously shade for the parking lot too. It's a 15-year power purchase agreement that at the end of that agreement we'll also be able to potentially purchase the solar system and have it in our repertoire for even better rates. We also wanted to note that we got LEED Gold certification last month on both of our clubhouses, which was a significant event. The only other stadium complex within our league, our Cactus League, is the Salt River Field Stadium. So we're the second facility within the Cactus League to have a LEED Gold certified buildings. So we're very proud of that accomplishment. Right now we're under construction on our stadium improvements. If you go out there right now, you'll see a lot of activity going on. The berm area is completely torn up. They're installing a new walkway. The project also includes stadium upgrades, an identity remodel, and painting of the facility. The outfield circle will be improved at the berm area. New gateway entries into the stadium will be completed. A new souvenir store that's going to double, more than double what the existing souvenir store was, and be a new part of the unique entry into the stadium. It also includes an ADA ramp to the sports field, which was lacking, new field level seating, which will show in the following slide, as well as infrastructure improvements that were needed at the stadium. So here's just some of the pictures of some of the activity that's going on right now. In that bottom left corner, you can see the excavation that's taken place. You see the seating of the seating bowl, that's right behind home plate. That excavated area there of about 8 feet is where there's going to be at least two new rows of field level seating behind home plate. So those people that had front row seats before, well, they're not front row seats anymore. They're going to have new field level seating to improve the experience at the stadium. You can also see the souvenir store that's going up pretty quickly, actually. That souvenir store is going to have a second level that's going to have a new concession area and a ramp walkway to the seating bowl along the third base line. And just as a heads up, at the November 25th council meeting, we're going to come back for a request for a funding allocation for the second phase of the stadium improvements. As you recall, we had a study session presentation in June where we recognized some of the improvements weren't able to be funded as part of the first phase. So on November 25th, we'll come back for a proposed funding of the second phase, which will specifically include the third base expansion, which is the social seating area, and the seating expansion along the third base line, as well as the kids interactive zone. And those two components it's estimated that the construction cost for that will be $3.6 million. As we stated, that will come from savings from 3 of our capital projects. The Lake Pleasant Parkway project achieved savings of $1.5 million at the end of construction. The Truck Road Reliever project achieved $1.5 million in savings, and we anticipate the 91st Ave construction project from Butler to Mountain View right now is anticipated to have about $600,000 in savings. So that's what we're going to propose at the November 25th council meeting, is to approve that funding for this second phase of improvements at the stadium. With that, I'll take any questions that you might have.
Thank you. Questions? Good, thanks.
Thanks for the update, Andy.
Thank you.
You and Ed and the staff continue to do a great job overseeing these contracts and getting the work done in a timely fashion. Thank you.
Thank you.
How about tonight's baseball game?
The last item on the study session agenda is an update on the Peoria Sports Park project. Of course, this is the project that is adjacent to our stadium. And before Scott makes his presentation, I want to add one point of clarification and underscore this, because there's recently been continuing discussion by proponents of digital billboards in the West Valley that have misstated our intentions with respect to the Peoria Sports Park project. Nowhere in this project has there been, or are there now, or will there be digital billboards. And in fact, within the agreement that the city has with the developer, they are expressly delineated as not an acceptable feature within this project. So that's a little bit of a diversion from the regular presentation, but I thought it was important, since this was on your agenda tonight, to make note of that. So with that, I'll turn it over to Scott.
Just a second, Mr. Ames.
I think you mean digital advertising, right? We do have digital lights up there that says this is the Peoria Sports Complex.
Absolutely.
Advertising you're talking about.
Yeah, just I'm happy to clarify that, Vice Mayor Ames. What we have is, and what you just saw from the presentation that Andy made, we definitely have what he calls those pylon and those lower identifying sign structures for the district, but they are not advertising billboards. And advertising billboards are not something that is going to happen.
They're just signage.
Correct.
Great, thank you, Mayor and Council. It's great to be before you again to talk about our Avenue Shops at P83 project. This is just an update to kind of give you a sense of what has been going on since March of 2014, that being the date that Council approved the development agreement and ground lease for this project. What I thought I might do as a refresher is just kind of quickly go over some of the salient points of the site plan. The site plan, as represented in the pink color here throughout, represents retail uses. We have about 84,000 square feet total of proposed retail use within the proposed project. The green areas here and here, green represents entertainment. We have a plan of about 17, almost 18,000 square feet of entertainment-related uses. The light blue that you see throughout the site plan here represents restaurants of approximately 35,000 square feet in total. And then this darker blue right here represents a 140 room, 5-story hotel with 10,000 square feet of convention space, meeting space, as well as 2 levels of parking beneath, accounting for 201 structured spaces for parking. This is a full-service hotel with a rooftop lounge and bar. What we also have here and here are proposed parking structures. This parking structure here, the main structure of 83rd Avenue, containing approximately 1,800 structured spaces. The smaller level and parking garage here representing a total of 757 spaces. Then when you account for the 201 spaces associated with the hotel and the remaining 407 surface spaces, gives us a total parking of 3,157 spaces for the project. So this is a planned retail entertainment project to take advantage of the offerings of the sports complex with connectivity over 83rd Avenue to the Harkins complex as well. The other thing I might just reference for refresher purposes is that we kind of saved this corner here as a distinct possible phase 2. As a deliberate action, we thought that once we get some traction on this main phase 1, there could be a much higher and better use that emerges as a phase 2, so we wanted to kind of keep that opportunity available to take advantage of that as a future phase. Just to give you some rendering concepts as to what we believe this could look like. For orientation purposes here, we have the sports complex. Here we have the Alter Group buildings. Here is the placement of the main parking garage oriented on an angle as ways of creating view corridors into the project as well as into the stadium and lessening the visual imprint on 83rd itself, creating a pedestrian corridor interior into the project for informal and formal entertainment opportunities, gathering places, water features, landscape nooks and crannies for all kinds of outings and adventures, more formalized meeting places and gathering areas for the retail dining and entertainment experience. Again, just a rendering, different vantage, expressing kind of the same development pattern for the proposed project. So the yes.
Scott, can you back up one slide, please?
Yes.
Where on the medium are the Z crossings that Andy was talking about in his presentation?
Okay, that would probably be best shown on the site plan. So right here, you may recall from the rendering, this was that circular grass area with the flags as a potential meeting space. If you see this right here, that is the proposed placement of the Z crossing. And its purpose is to provide a pedestrian connectivity from the stadium through the project across 83rd in a safe and efficient manner over to the Harkins anchored area on the west side of 83rd.
Okay, so can you go back to your rendering of?
Yes.
Right there, would you please update your slide to show that Z crossing?
Yeah, essentially it's off the slide.
Yeah, I know, it's actually, according to your last slide, it should be right across from, yeah, right down there, so maybe included in your next rendering.
Yeah.
Thank you.
Okay.
Oh, okay.
Mr. Ames?
Yeah, can you, yeah, I see some names here. Are these real names or?
No, they're just intended to just
Just
kind
give an idea,
Yeah,
there will be a name
exactly.
there.
Yes.
Okay. I'm anxious here.
Okay, so then the next part is really to talk about, well, what's happened since March and kind of separating the discussion into things that Peoria Sports Park LLC as the developer has done and things that the city has done. So first starting with Peoria Sports Park. Their first mission after March of 14 was really to gear up for the sales and marketing part of what they're responsible for doing. In the development agreement, it listed out a series of stipulations that the developer has to meet and perform with to the city's satisfaction, including entering into an agreement with a retail co-development partner, including securing 100% of the construction financing for the project, securing 100% of the equity financing for the project, and a host of other stipulations. So the first thing out of the gate was to get the marketing materials for the sales and marketing effort underway, establish the conversations with the brokers in terms of the tenants and creating the tenant relationships. As part of that, PSP attended the International Council for Shopping Centers, ICSC, main event in Las Vegas, again reaching out to potential co-development partners, financing entities, and tenants for the project. Continuing that effort over the summer, and then again going out to ICSC for their San Diego West Coast event in October of 2014. EDS staff joined in that effort, not only for P83, but also for other retail spaces that have vacancy throughout the city. Working with the broker network for tenant relationships has been ongoing ever since the March timeframe. And as I mentioned, joint marketing efforts, we're actively involved in that with the developer cumulatively and individually as well. Additionally, PSP working with retail co-development partners, PSP working with equity and debt financing companies, and ultimately assembling a financing package and retail co-development package that needs to be submitted to the city that we're expecting in the next couple, 3 weeks. In terms of city efforts, there are things that we needed to get done in order to move this project forward. One of which was the planning department's work in terms of finishing the PAD zoning amendment that was necessary to enable this project to go forward. That was completed in August, so that's done. The city has notified the San Diego Padres and the Seattle Mariners of our intention to move forward with the project and provided them with information that they requested as part of keeping them up to date as to the current status of the project. The council back in September approved the Alta Group ground lease amendment, and that was very important because we needed to seek resolution and agreement with the Alta Group relative to how the placement of the main 83rd Avenue parking garage was going to affect their leasehold. So that agreement has been reached, and so that contingency in the development agreement has been resolved. So that was very important. In anticipation of receiving the financing package and the co-development partner package, we've already engaged Ernst & Young. This is the same firm that we used to evaluate the initial developer proposal. To supplement staff review, Ernst & Young will be looking at those proposals from the developer and vetting them to make sure that we're getting the best possible co-development partner as well as the best possible financing package from bona fide lenders and equity providers. So that is all geared up. We're ready to roll in that effort as soon as the developer submits those packages. The next steps are for PSP to submit those proposals, for us to start and for Ernst & Young to start their review and vetting of the proposals. We're anticipating a council study session on the outcome of those reviews, either for the end of January, beginning of February. And the time sensitivity associated with that is that the DA, the development agreement and ground lease automatically terminate in March, but for the developers satisfying those DA stipulations. And it was structured purposely in that way to enhance performance relative to those stipulations. So that is the current status, that is the plan next steps, and I'll be happy to try to answer any questions you might have.
Thank you. Questions? Mr. Ames?
Yeah, that DA and general ground lease, did you had a certain percentage there that had to be accomplished at that time, or was it 100%?
In terms of the tenant leases,
Yeah.
the tenant lease stipulation called for 80%.
80%, okay.
Yeah, so now, in terms of the order of importance as to how the dominoes need to fall, really it falls in terms of, one, the financing package. Is the financing there? And then two would be, is the co-development partner there? Because a positive response on both of those really enables the tenants to execute those leases. But yes, you're correct, it's 80% for the leases.
Questions? Comments? Thank you.
Thank you.
Thank you very much. We're adjourned.